lady. Hey, I got a lady. Hey, name is the upper echelon, she a debater. Baby, she can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart, she got the heart, she got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon, she a debater. Baby, she can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart, she got the heart, she got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Stupid can't play with smart.
Good morning. How y'all doing? Make sure y'all hit the like button. Make sure that you hit the notification bell. And if you are in the chat and you are not subscribed to my channel, please make sure that you go ahead and hit that subscribe button if you enjoy my content. So as you guys know, Quadasia Johnson was officially detained, arrested yesterday, and officially charged with first-degree unaliving, the first-degree unaliving of the beautiful Romika Meeks. She is now in custody, and she will be going to court this morning at 11:30. Now, I did watch Trina's live this morning that she did, letting us kind of know what's going to happen as far as a Zoom meeting. Unfortunately, according to Trina, for this case, there will not be a Zoom meeting. It is in person only on 26 in California at 11:30 Central. So I wanted to come live today because this morning, because first of all, for those of you who did not see Quadasia's mugshot, I wanted to make sure that I showed it to you guys. I wanted to make sure that I showed you guys her mugshot. This is her here, her and her stash. Okay. And I also wanted to go over a couple of predictions as far as what may happen today. Now, there's a lot of people, welcome everybody coming in. There's a lot of people that believe that she will be released on electronic monitoring, which I guess could be a possibility. I personally do not believe that that's what's going to happen. And I'll get into why I don't think that's what's going to happen. And again, I don't know. I could be wrong too, but this is just going to be my prediction. Okay. Before I get into that, I want to get into this post that Brown Mike did. Now, Brown Mike is a really, really popular concealed to carry instructor here in Chicago, Illinois. He's been viral a couple of times. Now, initially, he did speak on the Romika Meeks case when it first happened. He was not quite sure if this was self-defense or not, and he kind of stayed away from speaking on that. because he said it could have been self-defense, right? So yesterday he did a live stream. I watched it. If you want to see his live stream, go to his page. It's Brown Mike. This is his profile picture, where he kind of talks about the rules and regulations of having a CCL, and about the need to shoot versus the want to shoot. And in the live that he did yesterday, as a professional and from the information that he's obtained about this case, he's come to the conclusion that Quadeja did not need to shoot. Quadeja wanted to shoot. There's also a lot of talk around whether or not what Quadeja did was overkill. Now, one of the things that will have that first degree murder charge stick for Quadeja is if the prosecutors are able to prove that Quadeja intended to kill Romika. Her whole purpose and intention was to kill her. Now, there is a lot of argument around whether or not that is true. Me personally, I just don't see where the argument comes from, because if somebody is consistently shooting back to back to back to back, that's no longer you trying to stop them or you trying to protect yourself. At that point, you are trying to take their life, because we all know what a bullet does, right? So when you're putting more than one bullet into somebody and then you continue to fire, that shows that you have an intent to kill that person. Period, point blank. There's no way to dance around that. She wanted to kill Romika Meeks, and no, that is not allegedly. Okay, that's not alleged. That's a fact. Okay, she tried to fill her up with lead. That is what she tried to do. And now she's in one of the roughest jails in the United States of America, Cook County Jail. And from what I hear, Romika Meeks has family in that damn jail. So have fun. Now, let's get on to what Brown Mike said really quick, and then we're going to talk about why I predict that she will not be released today. I could be wrong, but that's my prediction. So Brown Mike wrote a powerful status connected to this picture here of Quadeja. Brown Mike said, you can't out-train a violent culture. You can't out-teach a pride-based operating system. You can't introduce walk away at 25 when it wasn't modeled at 5 years old. This is why trauma-informed firearm education matters. This is why culture and training have to meet. This is why cases like this keep happening. She was charged. We're watching another tragedy unfold. 2 lives gone before a verdict is even reached. More of the same avoided issue. But the real story isn't the headline. It's the culture behind it. No matter how many times we drill into folks, when they cannot shoot, you will never out-train a violent culture. If the culture says reckless, the decisions will stay reckless. I'm going to speak on that in a minute, okay? Because this definitely is a reckless culture. Because as you all have seen throughout the couple of months after this tragedy has occurred, we have seen so many different opinions from so many different people. And I am astonished by the amount of people who believe that this young lady did the right thing. I'm astonished by it. Okay, so when Brown Mike says that this is a reckless culture, that is a fact. There's too many people out here that cannot understand that what she did was reckless and it was wrong. So let me go on to say, read the rest of what he goes on to say. Her CCW instructor was a relative. Okay, let me read that again. Her CCW instructor was a relative. Maybe she was trained well, maybe not, can't say. But no amount of class or range time can fix untrained emotions. Maybe she learned the laws, maybe she learned technique, but what she didn't learn is what destroys us the most. How to manage conflict, how to detach from toxic relationships, how to regulate emotions under pressure, how to walk away before the moment turns deadly. As a family and educator and researcher, when someone's family member is their concealed to carry instructor, especially in our community, several predictable problems show up. I'll point those out in the comments. But here's the part that's going to hurt. If your family didn't teach you how to choose a better man, how are they going to teach you how to avoid the wrong ones? If you don't know what goes on behind their closed doors, how are you going to teach them how not to create the same chaos behind your own? I love when parents say, I taught my child everything they need to know. No, you didn't. You taught what you knew. You didn't teach what you never learned. And that gap, that's where tragedy lives. When parents say, I taught my child everything, I know none of us can teach what we never taught ourselves. This isn't about a gun. This is about the internal battles that were never trained, never named, and never healed. Someone like Holly had no business being with Carlos in the first place. But that's the real battlefield. Attachment without training, emotions without tools, relationships without readiness. We keep losing young men and young women not to firearms, but to the dysfunction that shaped them long before the gun was ever introduced. Until parenting evolves, culture will not change. And until culture changes, these tragedies will continue. What do you think the culture needs to teach better? I love what he said there because it's so true. When people say guns kill people and we need to get rid of the guns, I love when people do the retort that by saying, no, guns don't kill people. Stupid motherfuckers with guns kill people. And Quadeja is a stupid motherfucker with a gun that took a life unnecessarily. Unnecessarily. So, she has been charged, rightfully so. And I agree wholeheartedly with Brown Mike when he says that you can teach a CCW, you can have a CCW instructor, you can have the best instructor. You can learn all of the laws, you can learn all of the technique, you can be the best shooter, you can be a sniper. But if you are not emotionally ready to be a firearm owner and have a CCL, you should not have one. Okay? There's too many people running around the internet that are taking up for this young lady and spreading false information and saying that it is okay to shoot someone if you're afraid to fight. No, if you're afraid to fight, the first thing that Holly should have done was to not antagonize Romika. The first thing Holly should have done was to stay off of the internet going back and forth with the young lady that she claims that she's afraid of. The first thing that Quadeja should have done was to not even remove herself from her vehicle. She should not have engaged, but she did, only to kill her. So we're not going to justify wrong on this channel, okay? She was wrong. As a person with a concealed to carry license, you have a greater responsibility than the average citizen. Your responsibility is that you have to have a little bit more self-control. You cannot purposely am I back? Can y'all hear me? Okay. You cannot place yourself into situations where you may have to use your weapon. It's not only your responsibility to use your weapon appropriately and responsibly, but it is also your duty to make sure that you do not go out of your way to insert yourself into situations where you will have to use the weapon, because that's no longer self-defense anymore. Okay? So let's remember that if we don't remember nothing else. Guns don't kill people. Stupid motherfuckers with guns kill people. Now today she has court at 11:30. Excuse me, I'll drop my phone. So I kind of want to go over what could possibly happen with her today. Let's see. So I did look it up. I did do a little bit of research. And because you guys remember, okay, so we're talking about bonds and all of this stuff. Now, Chicago doesn't do cash bail anymore. what it does is what you call a detention hearing. But we're going to get into that. I'm not going to be live too long, but I did want to drop a little bit of knowledge on y'all this morning. Hold on one second. Let me see something. Let me put my mute. So, give me one moment, y'all. Okay. So, in Chicago, somebody charged, or in Cook County, someone charged with first-degree murder being released the next day, especially on electronic monitoring, is extremely unlikely under normal circumstances, unless something happens to where or some sort of strange occurrence happens. And I'm not saying that she won't be released. I'm just saying that it's unlikely. So Illinois eliminated cash bail in 2023. Instead, judges decide to detain versus release. Okay, remember that, y'all. They decide to detain versus release. Under the new law, first-degree murder is one of the clearest detain eligible charges, meaning that because she murdered someone and she's in there under one of the highest charges, it is highly unlikely that she'll be released. Now, this is the detain versus release is under the Safety Act that was put in place in 2023 in Cook County or in Illinois. Okay, so for first-degree murder, the judge almost always finds the charge is extremely serious. The person poses a danger to the community, and no conditions of release will reasonably protect the public. Don't forget, Quadasia Johnson, this fool right here on the screen with the mustache, killed a young lady unreasonably around children in a busy community. If you remember the crime scene, there were people walking back and forth with book bags, students. She was within 1,000 feet of a school. So the eligibility for her to be released to the public to await trial on electronic monitoring would mean that they determine that she is not a danger to the community. The crime that she committed alone shows that she's a danger to the community. But let's carry on. So in any event that those three things are true, the charge is extremely serious, the person poses a danger to the community, and no conditions of release will reasonably protect the public. When all three of those things are true, nearly every person charged with first-degree murder in Cook County is held in jail for pretrial. Okay? The law doesn't completely forbid electronic monitoring for murder, but judges almost never grant it. Why? Because electronic monitoring does not protect the public. Electronic monitoring does not prevent violence. Judges risk major backlash if a defendant reoffends while on electronic monitoring. States attorneys strongly argue for detention in these cases. The only time electronic monitoring happens in a murder case is when the charge is downgraded in the state of Illinois, or when the facts are extremely unusual. Self-defense cases, clear evidence problems, wrongful ID, elderly defendants, etc. Okay, so it's possible that she could get electronic monitoring. I'm gonna be transparent. I hope that she doesn't. Hey, everybody coming in the chat. I'm not really looking at my comments, but I'm prayerful that she does not be. I hope that she stays her ass in jail. I hope she stays in there. And then also, you guys know this is not going to be some people are predicting that she'll take a plea. I don't think she's going to take a plea. I don't know. That's too far out to determine, but I don't know. What I will say is fighting a murder case is expensive. So I don't know. Maybe she got it like that. I don't know, but we'll talk about that on another live. Not to mention, y'all, okay, don't forget, this case is unique because a grand jury was held. A grand jury has already determined that Quadasia, or I'll say this, the prosecution has already convinced the grand jury that the first-degree murder charge is appropriate in Quadasia's case. Okay? This is if you missed the live that I did last night, go back and watch it where I talk about why the theory that Quadeja was overcharged is completely ludicrous. It's completely ludicrous. Okay. And the reason why I said that, if you guys go back to my previous live, is because in order for Quadeja to have been charged in this particular case, the grand jury would have had to see clear evidence from the prosecution. The prosecution was able to show the grand jury something to convince them that she is guilty. That speaks volumes right there. Just because we haven't seen it doesn't mean anything. The grand jury saw something that they said, well, damn, first degree. That's a serious charge to put on somebody. First degree is just not thrown around like Skittles just because you feel like it. Please don't let nobody tell y'all that. Okay. Now, the fact that she was just charged and detained yesterday, that tells you a lot. Shout out to Sunshine for that super sticker. I appreciate you. Thank you, I'm Chosen. I'm Chosen said, I think the final nail was posted and we're going to have a lot of holidays together. We're going to talk about that too. Floria says, my 19-year-old nephew was gunned down last night. In May, he has set of twins. I'm sorry to hear that, Floria. I'm gonna keep you and your family in my prayers. It's just too many tragedies that's just going on. Senseless stuff, senseless shit. So if she was just charged and detained yesterday, that already tells you a lot. If the judge or the prosecutor believes she should be out, she likely would not have been detained at intake. Okay. Being held overnight suggests the state filed a petition to detain her. Now, that is the process for those of you guys that don't know. So I'm going to tell you basically kind of like what's going to happen today. So what's going to happen today is they're going to determine whether or not she's safe to be released into the community to await trial. However, in a case that is first degree murder, now don't quote, well, yeah, you could quote me. The prosecution is going to file a petition to hold her. I forget what it's called, but there's a petition that they're going to file to keep her detained. The prosecution wants to keep her detained, and then they're going to determine whether or not that's appropriate in this case. Okay, but we'll see. So let me finish what I was saying. So being held overnight suggests that the state filed a petition to detain her already. They believe that she is a danger, and they want her held until trial. That means today's hearing is most likely a detention hearing. Remember, I told y'all that. It's a detention hearing, not a bond hearing. It's a difference. Okay. Here in Chicago, it's called a detention hearing. And the state will push hard for her to remain in custody. So there's a lot of people out here praying on their hands and knees. They was last night praying that Holly Johnson get released. But I'm here to tell you that the odds are against you guys. Holly is probably not going to be released. She may be, but it's possible, but not probable. Okay. Now I have a couple of statistics here for you guys. So real world Cook County numbers. Okay, so these are actual statistics from Cook County. The statistics show that over 90% of people charged with first degree murder are detained at pretrial. Only a very small fraction receive monitored release, usually in cases where the charge later changes. Okay. So I'm gonna say this, because this is a what she's saying is a self-defense case. It's possible that she could be released on electronic monitoring, but I just don't see it happening. I don't know. So what I found here, it says there is a less than 5% chance that Holly will be released today. So I think that Holly probably needs to be praying to whoever it is that she prayed to. Okay, because the odds are against her. Some lawyers would say closer to 1%, unless the case has a major evidentiary issue or the prosecutor agrees to release. Basically saying that the only way that Quadeja will probably be released today is if the prosecution agrees to it. And I highly doubt that they'll agree to it because I'm pretty sure that they put in a petition to keep her detained. Okay. So if people are believing that she'll go home, they're probably misunderstanding how the new no cash bail system works here in Illinois. And this is why I say that the law is very, very, very complex because it differs from state to state. So if you live in the state of Idaho, or if you live in the state of Wisconsin, it's going to be very different than what happens here in Illinois. So you have to literally, if you want to really like delve into this case, study the statistics, the numbers, the law codes here in the state of Illinois. Okay, because just because somebody got off with first degree murder in Florida doesn't mean that they're going to get off with first degree murder in Illinois. And just because somebody got off with first degree murder in Kentucky, or just because they were released to await trial in New York, doesn't mean that that's what will happen in Illinois. So we have to be very careful when we say certain things or compare different cases to this one, especially if the cases that you're comparing are out of state. And I do want to say that anything can happen. You know, this is only the beginning. Anything can happen. She can be released today on electronic monitoring, even though I don't think that's likely. She can go to trial and be charged, fight the case and get a lesser charge. She can be completely let free. Who knows what's going to happen in the future? All I'm going to do is stay prayerful that they really throw the book at her, and that they convict her of first degree murder and throw her motherfucking ass up under the prison is what I'm hoping. So let's continue. And then if people believe that strongly believe that she'll be sent home today, they probably don't realize murder is almost always detainable. So I want people to remember that. This is a pretty serious case. This is she's been charged with first degree murder, you guys. That is a crime that is almost always detainable, meaning that if the state suspects you of murder to the point to where they've had enough evidence to even charge. Let me say this too, what people are not understanding. A lot of people are saying she was just charged, she wasn't convicted. That's true. She was only charged, she wasn't convicted. But I don't think that a lot of people realize how much it takes to charge someone. To simply charge a person is very, very complex. Evidence is involved in charging. The state's attorney will not agree or the grand jury will not agree to a charge without a sufficient amount of evidence. So I want y'all to remember that. Some evidence is out there, possibly that the public has not seen yet, that was strong enough to put that charge on her in the first place. No, she hasn't been convicted of it because in the United States of America, you are considered innocent until proven guilty. But also understand that they're not going to charge you with anything unless they have the evidence to do so. So there is something here that exists where the state's attorney, the grand jury, 12 to 16 of her peers saw something and heard something and came to the conclusion that that was the appropriate charge for her. So please do not throw to the side, oh, she was just charged. Yes, she was just charged. But a lot goes into charging someone. It's not, I told y'all yesterday, the state investigators and the grand jury go up to Chicago Park District and play bubblegum in a dish and decide to give her first degree murder. Something exists as far as evidence. That is the reason why she is charged with first degree murder. And we'll find out once the trial ensues what that thing is. So let's see. Or people could be assuming based on past years that use a cash bail. But since 2023, Cook County judges detained nearly let's say that, okay? Since 2023, Cook County judges detained nearly all defendants that are charged with murder. Okay? I need y'all to understand that. If she was officially charged with first-degree murder, and she, well, not if, but she was charged with first-degree murder, and she's going to court today, the overwhelming likelihood is that she will remain detained. Being released on electronic monitoring for a recent murder is extremely rare. Extremely rare. Let me look at some of my comments. I doubt they waited all this time to go get her, only to let her out the next day. And then, Nola Bunny, the prosecution is going to fight it. They're going to fight it. So let's talk about, because they're going to fight it because they've already put in a petition, I'm sure. But let's talk about this, y'all. So what is going to happen today, y'all? What is going to happen? So today is what you would call her initial appearance. She'll be brought into a bond court, which is now called pretrial hearing in Cook County. A judge, a prosecutor, and a public defender or her private attorney, because I heard that she had a private attorney, will be present. During that initial appearance, the judge is going to confirm her name. The judge is going to confirm the first-degree murder charge. Because it's a male judge, is going to confirm that she has an attorney and that she understands why she's in court. The next thing that's going to happen today, after that is done, is the state is more than likely going to file a petition asking the judge to keep her detained with no pretrial release. Now, the prosecutor, when he puts in that petition, he has to prove that that it's a serious charge, but there ain't nothing to prove there because we know it's a serious charge. There has to be clear and convincing evidence that she poses a danger to the public. Now, the girl was playing Wild Wild West in a 500 feet away from a fucking school. I don't know if what else needs to be. There ain't too much that needs to be proven there. Okay, ain't too much need to be proven that she's a danger to the public. She's a danger to the public. She has poor impulse control, poor decisions, poor de-escalating techniques. She doesn't need to be in the community. And I'll talk about that later. But if you want to look at her behavior on social media since the murder, she's probably a lunatic. I think that she might be a psychopath. The way that she's been flaunting around and bragging about getting ready to celebrate her son's first this and first that after she just murdered somebody, she's probably a psychopath. So I think the bitch needs to stay detained. I think she's clearly a danger to the public. The other thing that the prosecutor must prove is that there are no conditions, including electronic monitoring, that can keep the community safe. Okay, so the prosecutor has to prove that it's a very serious charge. Murder qualifies. He has to prove that there is convincing evidence that poses that she's a danger to the community, a danger to the public. And then the prosecutor also has to prove that electronic monitoring or any other condition for that matter cannot keep the community safe. Then after that, this is what's going to happen today. After that, after the prosecutor files the petition, the prosecutor has to then present evidence. Now, it's not a full trial. It's more like a summary of evidence, kind of like they did at the grand jury. So the prosecutor is going to describe the shooting. They're probably going to show any footage or video. They're going to go over all the witness statements, the defendant's role in the situation, whether or not she fled or turned herself in, if there are any threats or retaliation or gang involvement. I want you guys to also know that, because I was hearing a lot of people that were like saying, oh, I don't know why they're online doing all of this. You know, the police are going to do their job. Well, one of the things that is the police job as far as investigations is they literally have a whole cyber unit that their job is to sit online, look for evidence, watch the perpetrators' pages, watch what other people are saying. See, I'm sure they watched the witness statement that was on that podcast not too long ago. Their whole job is to sit there and watch activity online. Okay? So one of the things that we have seen are threats being made um, from Quadacia's family. I think I saw a post with one of her family members, because his last name was Johnson, said the Johnsons don't fight, we shoot people's faces off. I'm almost 100% sure that that's something that the cyber crime unit probably has. Everything that she's been doing, they have. All of the arguing back and forth that the auntie has been doing, they have. All of the snarky remarks that she's made on her YouTube channel, I'm sure the cyber unit has. Because of the tension, because this is highly publicized on social media, that's not a good look. She's a fucking idiot. Her auntie is a fucking idiot too. Because if her auntie really cared about her auntie would have told her to get the fuck off of social media. But no, her auntie wasn't doing that. Her stupid ass auntie was posting her OnlyFans and promoting her YouTube channel and talking shit when she should have been shutting the fuck up. I really believe that you helped your niece get locked the fuck up. I just want you to know that. Yeah, you helped her get locked the fuck up because y'all thought y'all were being cute. Y'all was trying to rub it in people's faces that she hadn't been arrested yet. And now look at her dry face ass. Look at this big face bitch now. Locked up with a half doobie wrap and a mustache. Looking salty than a motherfucker. Hey, I'm Chosen. Thank you for that. Let's see, what else? Another thing that the prosecutor is going to present is whether or not oh, thank you, y'all. Thank you, I'm Chosen. Whether or not the weapon was recovered, and obviously we know that the weapon was recovered. They only need probable cause, not proof beyond a reasonable doubt in this case, okay? Then after that, the defense attorney is going to respond. So after the prosecutor presents evidence, and again, it's not like a whole trial, it's just going to be like a small summary of the evidence that they have, kind of like I said, like in the grand jury. After the prosecutor does that, then the defense attorney is going to respond. Her attorney will argue reasons she should be released, and I don't know what those reasons could be. One of the things that the prosecutor is going to, not the prosecutor, but her defense attorney is going to argue is that this was self-defense. Obviously, that's going to be on the top of the list. She's going to say this was a case of self-defense. She's going to say that Quadacia was attacked first in most cases. She's going to say there's inconsistencies in evidence. She's going to try to push that Quadacia probably has no prior criminal history. She may bring up employment or something like that if Quadacia has a job, caretaking or parenting, but we know that her child is not even in her custody anymore. She's going to probably push that Quadacia is not a flight risk and ask for electronic monitoring as like a middle ground. But in a case of murder, those arguments very rarely overcome the state's petition. And then after that, the judge is going to make a decision based on the Safety Act that was put in place in 2023. Now, the judge is going to have two options, which is detain her or release her with conditions. Which means if she's detained, which is the most likely option, she's going to be detained with no bond, no release, and no electronic monitoring, which is the standard outcome for first-degree murder in Chicago. Just to let y'all know, that's the standard, unless something unique happens, because this is a self-defense case. And to be honest with you, a lot of weird shit has been going on with this case anyway. So if something happens to where she's released, then it just happens. But whatever. Now, if she's released with conditions, that's very rare. But that would mean that she's more than likely going to be released and with an ankle monitor, home confinement, no contact with the victims or witnesses. That's going to be interesting if she's released on electronic monitoring, because if she can't have any contact with the victims or the witnesses, then that would mean that she can't have any contact with Carlos, because Carlos is considered a witness. Interesting. In some cases, GPS. So now that in that situation, that's probably only going to happen if the facts strongly point towards self-defense, or if there's issues with the evidence that the prosecutor have, or if the judge just believes that she's not dangerous, but that's unlikely. Then after that, they have to set the next court date. So if she's detained, she's going to go back into custody after the hearing, and she's going to remain at Cook County Jail until the trial or until further hearings. Okay, let me look at some of these comments. Hope CPS lets her know that the family let her have her child. Wow. I think she's going to try to say that she was defending Carlos because him. Oh, let's talk about Carlos. A lot of people are saying that they want Carlos to go down too. My thoughts and opinions about, I'm just going to kind of keep it simple with him. I know y'all don't want to hear this, but yeah, I think Carlos got away with it. I think that Carlos manipulated Quadeja. He manipulated her, most definitely. He manipulated her, and he did a damn good job to where he did what he had to do to get rid of Romika. He manipulated her into doing it, and he never pulled the trigger. His hands are clean. I think that if Carlos was going to be charged, I think he would have been charged already with Quadeja. Now, he could be charged in the future, but I personally, I don't see. I think he got away with it legally. When I say I think he might have got away with it, I mean legally. Yeah. There's always a day of reckoning. So he's going to face his day of reckoning. I just don't know if it'll be in a courtroom. It might be on the street. It might be at the Golden Gates. Who knows? But it's coming though. Keep her like that. It seems like this will be a preliminary hearing today. Okay. What's crazy is she is not supposed to be around her child, but taking pics with him so desperate for attention. So what likely is going on with that situation, because a lot of people are confused, because yesterday I did tell you guys, I mean, it's really, that information was already put out there. But like I, reminded you guys yesterday, is that her son is a ward of the state, meaning that her son is in the care of DCFS. So a lot of people were confused because they're like, well, we saw her post her child yesterday. Well, not yesterday, but during the holidays. So how is he a ward of the state? Well, he is a ward of the state. The child is not in her custody. The child is in the custody of a family member. So because the child is in the custody of a family member, she still has access to her son. When DCFS takes custody of your child, they do not automatically just snatch your child and throw them into a random foster home. The first thing that they're going to do is ask you, do you have any fictive kin? Fictive kin is a family member, a close friend. It doesn't have to be blood relative, but somebody that you know and trust with your child. Do you know anywhere that we can place your child that you feel that your child will be safe? If not, then we have to place this child into a traditional foster home. A traditional foster home is somewhere where you will not even know where your child is. So obviously she had fictive kin, which is probably her mother. And oftentimes in situations where a child is placed with a family member, you're still going to have access to your child. It just has to be supervised. So if the person that has her child is in the same vicinity as her and is watching her with the child, then she won't get in trouble for being around the child. DCFS is not going to say that you cannot be around your child at all unless it's like super extreme situation. You would say that this is an extreme situation, but you got to remember the DCFS case opened during the open investigation. So she wasn't charged at the time that her case with DCFS was open. So I'm sure she has supervised visitation with her child. So it's not strange that we're seeing pictures with her and her child, okay? Because the child is with a family member. Gretchen says, I don't think she has her child. She doesn't. She does not have her child. She doesn't have her child. Her child is in the system. Her child is a ward of the state of Illinois. The child's guardian is the state of Illinois. And the state of Illinois placed the child with the caregiver. The caregiver is whoever her relative is. Could be a mama, could be her auntie or something like that. So she has access to the child, but the child is not legally in her custody anymore. This is what I brought that up last night too. Before I get off, I want to say this. I also brought that up last night, and I brought that situation up because a lot of people are saying that Quadeja did what she had to do to protect her and her child. And I wanted to make something very clear to you guys. If Quadeja was protecting her child and Quadeja was protecting, had to shoot and kill Romika because she had to save her baby, because that is the narrative that the Holly supporters are spinning, then I hate to break it to you guys, but if that were the case, then baby Carter would not be in the care of DCFS. As I explained yesterday, Child Protective Services is not going to snatch your child away from you because you protected them. They're not going to take your child because you shot somebody who was trying to harm your child. So that alone, that fact alone, that the child is not, that DCFS does not believe that she is a safe person to where that child should be around her unsupervised. The fact that the state of Illinois has already said that, that means that there's something wrong here when it comes to that self-defense claim. There's something that happened here that is unusual for the state to determine that you are not safe and that your child should not be in your care. So I do chuckle a little bit when I hear people say she was protecting her child. Well, if Hero Holly was protecting her child, then the state of Illinois would not have taken her child. The state of Illinois nor DCFS punishes a parent for protecting their child. Okay, period. So to say that Holly is right and that this is a self-defense case is to say that DCFS is wrong. It's to say that the police are wrong. It's to say the investigators are wrong. It's to say that the state's attorney is wrong. And it's to say that the grand jury was wrong. The odds are not in your favor. I'm just saying. The odds are not in your favor. But anyway, yeah, I'm about to get off here. I just wanted to do a really short live. And then after the decision is made on whether or not she'll be released, I'll come back later on tonight to cover that. Find out what happened, then I'll post it on my community wall. And then I'll also make sure that I know Brandy is cold as hell today. What is it today? I woke my dog this morning. And I'm like, damn, the Hulk out today. It was like 18 degrees. Yeah, but I'll let you guys know as soon as I find out. But y'all shit, y'all might find out when I find out. Live to discuss it later on today. And I'm going to be live quite on that this has happened every time anytime that we get some transcripts, we're going to be breaking them down over here and talking about it. So make sure that you hit the notification bell because I'm going to be going live and speak quite often and I don't want you guys to miss anything. So thank you to everybody who joined me. Thank you to everyone who hit the like button, and to any new subscribers. I noticed that I received some new subscribers the other day. I'm sorry, y'all. I'm looking at something. So shout out to all of my new subs. Welcome to the Upper Echelon Podcast. I will see you guys soon. Make sure on your way out that you hit the like button and the notification bell. All right, y'all. Peace.
Name is the upper echelon, she a debater, baby. She can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence, baby. She the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart, she got the heart, she got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart.